الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, in our lessons on Imam Ibrahim al-Halabi's Multaqa al-Abhur, we have, by the grace of Allah subhanahu wa ta'ala, been looking at the chapters on transactions. And we finished a very important discussion on riba, and then looking at the riba related to Dar al-Harb and clarifying some critical misconceptions related to that. Now, today we're going to be looking at Bab al-Huquq wal-Istihqaq. And this is a very important chapter on rights and third-party ownership and arising rights from a transaction. And these are much more common than you would think. The first aspect on istihqaq, on huquq, is what enters into a sale and what doesn't. And this is connected, if we look, Sadati, at an earlier chapter, right? Which is that what happens if you what is included in a sale and what is. So there's some overlap between these two chapters. So let's see what the author has to tell us, rahimahullahu ta'ala. Bab al-Huquq wal-Istihqaq. And we'll see today as well a number of important principles related to the methodology of the Hanafi school. Particularly today, we look at a number of issues where the role of urf, of custom, is highlighted, right? And how that affects rulings. This also, of course, then relates to the issue of determining the relied upon position of the madhab, and we are giving you a number of related readings, particularly to understand what is meant by al-ulu, what is meant by the masil, etc., so that you have some clarity there as well. And these are things that for those of you who are experienced students of knowledge, you should be looking up. So today, bi'idhnillahi ta'ala, we have a number of important outcomes that should be clear for you. That to examine rights, that what enters into a different learn the rulings of an unauthorized third-party transactions, bay'ul fuduli, and then we're going to rights arising is very common in transactions related to family and others. And also the fuduli, the one who transacts without. The first part on rights in sales. باب الحقوق والاستحقاق. قال الإمام إبراهيم الحلبي رحمه الله تعالى ونفعنا به وبكم. يدخل العلو والكنيف في بيع الدار. So the above floor and stables or outhouses, kanif can refer to a stable or an outhouse, is included, i.e. without having to be mentioned, in la dhulla, but not the external perch. So إلا بذكر كل حق هو لها, except by the mentioning of every right associated with the dar, with the property. أو بمرافقها, or you mention that I'm selling this بمرافقها, with its related rights. أو بكل قليل وكثير, with everything associated with it, big or small. فيها أو منها, in it or related to it. Right? Unless all related rights are mentioned. وعندهما تدخل إن كان مفتاحها في الدار. And according to the Sahibain, all of these things enter if their entrance is from the dar. So the first thing to look at is what is meant by a dar, what is meant by a manzil, and what is meant by a bayt. Right? So a dar, what is a dar, Sadati? What is a dar? So, right? That which has, so ما يدار عليه الحيطان, right? That which is surrounded by walls. Right? It could have a surrounding compound outside. A lot of dars had the compound inside the, inside. Right? So dar, right? Like the Arab house, what's called a Darul Arabiya, right? The Arab houses now in Syria, for example, they call it al-Baytul Arabi. Right? It's walled, but the courtyard, the compound is inside, but it's surrounded by a wall. Right? So it has residence plus a courtyard or a garden, other associated things. Right? So that's the dar. Now, do these things enter? So does the ulu, does the upper house or roof enter or not? Does the stable enter or not? Does the outside, the porch, so at the entrance of the house, of the property, there may be a dhulla, a shade. The guards might sit there. If people are waiting to enter the house, there'd be a covering, right? So that if someone knocks on the door and the people of the house are coming to open the door, they have shade and respect. But is that part of the house or not? So there's extensive discussion on this. Right? So do they enter without being mentioned or not? So So Ibn Abdin here discusses that ultimately it returns to the urf. He says, rahimahullah ta'ala, in Radd al-Muhtar, that حيث كان المعتبر العرف, that given that what is of consideration of whether it enters or not, custom. Does the roof enter or not? Because some places, like let's say, it would depend significantly upon custom, right? That is it part of the dar or not? Because you could have a one floor dar, you could have a multi-floor dar, right? So, you could have a dar that is being used as a store, right? So you sold a shop, but does the roof enter into it? Because maybe you use it for something else. So it returns to the urf. So Ibn Abdin says, وَفِي عُرْفِنَا لو باع بيتا من دار أو باع دكانا أو اسطبلا أو نحوه لا يدخل علو المبنى. Ibn Abdin says that in our urf, in his time, if you sell an apartment, right, or a dar, or a shop, or a stable, or a house from a dar, or a shop, a dukkan, or a stable, its upper floor does not enter unless the door to the upper floor is from within. But in selling a dar itself, these things would enter. So what does it revolve around? Custom. And so if you have the penthouse floor, for example, does the roof above it enter or not? It would depend on the custom of that land. And so we would consult the people who know about real estate, that what is the custom in this case. But what would be the best thing to do in these situations, Sadati? In terms of what's better in transaction?
Explicitly mentioned.
Yeah, these kinds of details. But sadly, people don't always do that. Okay. So that's the governing principle. Right? They enter if they consider to customarily enter. Right? So this is the text from Ibn Abdin. Right? In his time. Right? And the mu'tabar, he says, is the urf. Does it enter or does it not? Right? So for example, expectation that the garage is included. Right? If someone buys a home, for example, right? The expectation would be that the home would be included in the dar. Right? The expectation would be the home would be included, the garage would be included in the house, right? It would be not credible for it not to be included. It would be not. It wouldn't be credible for a garage not to be included, right? So in things like that, the urf is considered. Does it normally enter or does it normally not enter? Okay. Right? تماما. And then he says, ولا يدخل العلو في شراء منزل إلا بذكر نحو كل حق. Right? But the above floor does not enter in the sale of a home, a manzil, unless every right related to it is mentioned. And a manzil is like an apartment, right? Or a flat. Right? So if you rent the top floor in a building, would by default the roof be included as being owned by you? Right? As being owned by you? What would the governing consideration be here?
The custom.
The custom. And the custom. But the expectation would be that it wouldn't be. Because the manzil itself is the living area, basically. ما أعد للنزول. Like that. ما أعد للنزول. Right? So it would be the manzil, the understanding would be typically that it is the bedrooms, the living room, dining room, kitchen. Maybe some other things might enter. There may be a small garden or something, but that is a manzil. The top floor, the roof, for example, it wouldn't be an assumption, but custom can differ. In some places, Masiri, you guys probably have that in your state. If you have, these strip malls, sometimes there is, if someone buys a shop there, but there's housing above, can they assume that if they bought the shop, they also purchased the housing above it?
No.
No, right? تماما. And he says ولا في شراء بيت وإن ذكر كل حق. Nor is the top, is the top floor, or the floor above included in the sale of a bait, like a room, right? And bait refers to like a room, right? It could also be like a shop, like it's a one room thing. وإن ذكر كل حق. ولا الطريق والمسيل إلا بذكر نحو كل حق. Nor does the path or the stream or the water channel, except if you mention every right. Now there's two separate things. We're talking about owning the طريق. Here يدخل ملكه, right? That, do you own the pathway to your residence? If that's one thing, right? Do you own the path to your residence? Number one. Number two, do you have a right to use the road to your residence? What's the scenario? Let's say that Uncle Gukhan owns a large farm in rural Antalya in Turkey. And you purchased a house on that farm. Do you own the path to it? Do you own the path to it? Right? So there's farm property and you purchase a dar, but it has an access point. If you purchase the dar, do you own the exclusive road to it? This is the issue. It could be in a rural area, but also could be, let's say, there's a private property, and there's like a set of homes, and there's a road leading to your house. If you purchase that property, is the road to that now yours? Right? So this is what it's addressing. Ultimately, this goes back to the issue of urf. It goes back to the issue of urf. But what does he say? Rahimahullah ta'ala. Sorry, I'm getting confused by the buttons here. Right? Nor does the tariq, right? So you don't own the tariq nor the masil in such a sale unless you mention with all associated rights. But also, what are the associated rights that enter? Those that customarily are considered to enter. Right? So the same thing applies here as well. Right? The pathway, the water stream. Now you would need to have access to these, right? If there's a the water, that part of the water itself? No. Okay. وتدخل في الإجارة دون ذكر. But these things are included in the hire without having to be mentioned. They enter into the contract of hire without having to be mentioned. A contract of hire or lease, like if you rent the property, then you're also renting, i.e. the use of the road leading to the property. Imagine you rented the house, but they put guards on the gate. You can't enter. So you have to hire a helicopter. Of course, that would be ludicrous, right? So it would not be considered. Okay. So this is these are so to look at the issue of istihqaq. In some copies of the Multaqa here, this is broken down into a separate section. In some, it is not. So he says, rahimahullah ta'ala, right? So this is a fasl on al-istihqaq, on third-party rights. And the definition of a third-party right is ظهور حق ثالث. It's a right of a third party becoming manifest. So I sold this property to my younger brother, believing it was mine. But turns out that my uncle hadn't sold it to me, hadn't gifted it to me, he just lent me the property to use. So he'd actually legally gifted it to my sister. Did it and gave a set of keys, so there's a transfer of ownership, or he sold it to my sister. So I sold it to my brother, but then turns out that I didn't actually own it. It belongs to my sister. So these things get complicated, right? That's why the adage that the ulama use is "Kunu ikhwana," that be brethren, lakin ta'amalu kal ajanib, but deal with each other as if strangers. Deal with one another as though strangers. So if this happens, if some third party makes a claim, there are some underlying principles that define the addressing of claims. What are they? Okay. So firstly, the definition, right, of istihqaq, right, is هو كون المراد المراد بالاستحقاق ظهور كون الشيء حقا واجبا للغير. So that's Ibn Abdin's definition. It is a useful definition. You can summarize it that الاستحقاق is ظهور حق الغير, something turning out to belong to another party. He begins a section with some key principles. He says, البينة حجة متعدية. Right? Evidence is a proof evidence, like two witnesses, for example, or a title deed, for example. Right? I have a title deed. That's a bayyina. It's evidence. So that is a proof against somebody else. وَالْإِقْرَارُ حُجَّةٌ قَاصِرَةٌ. But an admission is a limited proof. Is a limited proof, meaning an admission counts only against you. It does not count for you. So for example, if I sold the property to my brother, but then I admitted that I'd already sold it to my sister. Right? My admission is limited to me. It does not count as proof for somebody against somebody else. So what are the consequences of that? He'll explain. He also says, وَالتَّنَاقُضُ يَمْنَعُ دَعْوَ الْمِلْكِ. And contradiction prevents. So you say, I own this, but you also say, I have gifted it. That prevents the claim of ownership. Right? You're claiming to own it, but you've also claimed to have gifted it already. Okay, so what are the applications of these principles? Right, so contradiction prevents the claim of ownership, but does not prevent the للحرية والطلاق والنسب. But it does not prevent the claim of your slave to be free, nor of divorce. Someone says they divorced their wife, but they also said they didn't. That contradiction does not prevent ولا النسب, nor the affirmation of lineage. Because we know that when it comes to claims of nasab, whose interest is given precedence in consideration?
The child.
The child, right? Someone says, it's mine. No, it's not mine. Right? So even though this is a contradiction makes claim of ownership problematic, but when it comes to freedom, you said the slave is, I've freed my slave. No, I haven't freed my slave. The slave is freed. Divorce, likewise lineage, right? Because in these, we err on the side of counting it. Okay. فلو ولدت أمة 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 مبيعة فاستحق فاستحقت ببينة تبعها ولدها إن كان في يده وقضي به أيضا. So if an Amma who was تناقض and the contradiction, and because it turns out that before that it belonged, the Amma belonged to somebody else. Um, um, than a sale, right? Because in a sale is a transfer of right, whereas rahan is simply a matter of the right to demand, right? It's simply a matter of a right to demand. Tamaman. Right? So the scenario should be clear, right? Someone said, "I'm a slave," so that admission, right? Does that establish a proof against somebody else? No. Right? So that's why it goes back to that principle. Okay.
فصولح على شيء فاستحق بعضها أي بعض الدار فلا رجوع عليه. Okay? If someone claims an unknown right, in a property,
there's a family home, and they never really sorted out who owns how much. Multiple generations of confused ownership. So Auntie Lubna says, this house belonged to our grandparents. This is a long story. So it says, okay, Lubna, we owe you. You know, she says, I have some right in this. I have some right in this. Haqqan majhulan, right? So they want to just resolve it. And as-sulhu khair, right? Reconciliation is good. Okay? Settlement is good. So what happened? So she claimed some right. Did they define how much did she own? No. But then turns out that some of the house was mustahaq. It belonged to a third party. Some other family member owned a quarter. فَلَا رُجُوعَ عَلَيْهِ. In this case, there's no returning of that settlement amount. Why? Why wouldn't there be a returning of the settlement amount here? Why wouldn't there be a returning of... Because what would the assumption be about that right that we settled regarding? It's from the part that did not belong to the third party, right? So Auntie Lubna says, I own some of this family home, this family mansion. Now they don't want Auntie Lubna to come and stay in one of the rooms, etc. Grumpy lady. So so they said they settled with her. Then turns out a quarter of the house belongs to Uncle Jamil. So the assumption would be that the settlement made with Auntie Lubna was from the part that wasn't from the third party, Uncle Jamil. So there would be no need to refund. However, it says وَلَوْ اسْتَحَقَّ كُلُّهَا أي كُلُّ الدَّارِ. However, if the entire property turns out to belong to a third party, رُدَّ كُلُّ الْعِوَضِ. Then the entire عِوَض, the entire settlement amount would have to be returned. Because then the settlement would be shown to, her claim would be shown to be what?
True.
False. Right? Auntie Lubna says, I own some of this property. So they don't like Auntie Lubna. They've been hearing this, that some of this property did belong to Auntie Lubna, but multiple generations of messed up inheritance. So they said, okay, they became religious. They want to settle with anyone who had a claim. But then turns out that the whole house did not belong to this strand of the family. The children of Uncle Jalil. Right? The house was proven to belong to Uncle Jamil. So then that settlement is necessarily contradictory, right? Because Uncle Jalil's children settled with this lady, and then turns out it didn't even belong to them in the first place. Right? Istihqaq. ظهور حق ثالث. It belonged to that third party, Uncle Jamil. So in this case, that settlement was contradictory. Her claim, which they accepted, she didn't have proof. Right? Her claim in itself is a claim of proof against somebody else? No. Right? So this goes back to those three principles of bayyina, iqrar, and tanaqud يمنع دعوى الملك that we saw. وفهم منه صحة الصلح عن المجهول. And from this, a principle is understood, which is that you can make a settlement on an unknown right. You can make a settlement on an unknown right. And there's difference of opinion amongst the madhahib regarding this, but why? Because it's possible, right, that people, for example, there's a beach house. So a few people pitched in together to quickly buy the beach house. They couldn't believe that they went to rural Rwanda and there's a beautiful beach house where there's desert on one side, greenery on the other, the sea. All, it's like, wow. So they bought it for $10,000. A few people pitched in. They don't remember who pitched in how much. But then they fell out with Uncle Mohan. So they don't know how much he owned of the house. They said, look, we'll give you $3,000 and you have no further claim on this house. Can you make such a settlement? So there's four parties. They don't remember how much Uncle Mohan owns of the house. Can you make a settlement in this case? Sadati? Yes, you can make a settlement in this case. Why? Because this is a haqq majhul, right? Stay with me, folks, please. Right? فهم منه صحة الصلح عن المجهول. You can make a settlement for an unknown right. عن المجهول أي عن الحق المجهول. This is mentioned in some copies of the text, not in others. So the sulh, this is further details in the section on sulh. And number two, because it does not lead to dispute. Of course, you cannot make false claims, but because it's many conceivable scenarios where someone makes a claim, but they don't remember the details. Another common application of this sulh an al-majhul would be, let's say you know that you had borrowed money from Uncle Zubair, but you forgot how much, he forgot how much. So you settle. Both parties, they said, okay. So it's majhul, it's majhul. So I said, look, I'll give you $2,000 and that clears the due. Both parties agree, they come to a settlement. That is valid. Right? So this principle that's understood from this, it's understood from many other texts too. You can make a sulh on an unknown right. وإن كان ادعى كلها رد حصة ما استحق ولو بعضا. That if he had claimed it fully, he returns the extent that turns out to belong to a third party, even if partial. So the scenario would be that he said, so Uncle Mohan said, well, I owned some of that beach house, so they settled on $3,000. But turns out that the beach house did not belong to them anyways. It was the property of Uncle Latif. So now the guy who took money from them, there's a mess, but the settlement amount with Uncle Mohan would have to be returned. Okay. Then we have Babul Istihqaq, Babul Fuduli, or Faslun fil Fuduli, the one who transacts without permission. And we'd explained the Fuduli a little bit last time as well. So he says, rahimahullah ta'ala, وَلِمَنْ بَاعَ فُضُولِيٌّ مِلْكَهُ أَنْ يَفْسَخَهُ. It is a right. The lam here is for haqq, right? يَحِقُّ لِمَنْ بَاعَ فُضُولِيٌّ مِلْكَهُ أَنْ يَفْسَخَهُ. It is the right of the one that a fuduli sells their property of to cancel the transaction, right? وَلَهُ أَنْ يُجِيزَهُ. And it is his right to also validate that transaction. But you can only بشرط بقاء العاقدين, as long as both transacting parties still exist, are still alive, and the item transacted over still exists, right? And the original owner, right, whose property was sold, also exists. So these four conditions are met. وَكَذَا بَقَاءُ الثَّمَنِ إِنْ كَانَ عَرَضًا. And likewise, the price, if it was a commodity. So you can cancel or approve. If any of these perish, then the default would be that the transaction would be unvalidated. So it would be cancelled, right? Because if any of these things perish, because the ruling of the Bay' al-Fuduli is that it is valid but suspended. And the wisdom of it, as we touched upon in the opening lesson last time, was that it's suspended because there may be harm, but there could be benefit in it. I engaged in a Bay' al-Fuduli once. I was sitting in Maktabat al-Bayruti in Damascus, and the owner stepped out. And this foreigner came, I think he was Saudi or somewhere, and he wanted to buy a book. So I sold it to him. Even though I didn't work there, I wasn't asked to sell, etc. I didn't actually give him a discount either. It's pretty standard to give 5 to 20% discount. I said it's this much. He gladly paid, went. So it was a big book too. I forget what it was. So in that case, why was it fine for me to sell that book without giving a discount?
If you had reasonable surety, it'd be okay.
Yeah, at reasonable surety, that'd be okay, because the books are there to be sold. I did not give a big discount or anything, so there's nothing to make me think that he would not be okay with this. So, normally, Bay' al-Fuduli is sinful because يعني لا يجوز التصرف في ملك الغير من غير إذن أو ولاية. It is not permissible to transact in another's property without permission or some type of agency or guardianship over it. You can't go and sell your neighbor's car normally. But if you're close with your neighbor, he never asked you to sell his car. He'd been struggling to get $1,500 for it. Now someone comes and says, I love that model car. I wish I could find one just like that. And your neighbor's gone hiking, and so you sell it. Now the better thing would be to say, look, would you buy it for this much? The guy says yes. Says, okay, I think we have a sale. I'll confirm with you within 72 hours. Your neighbor comes back. You say, look, I've got this guy. He's agreed to buy your car for this much. That's a safe way of doing the bay' al-fuduli. But sometimes, right? So in general, even when it seems in the interest of the other, make a commitment. Don't make a contract. Okay. So, وإذا جاز فالثمن العرض ملك الفضول. Right? And if approved, the price, that's a commodity, if the price is a commodity, belongs to the fuduli. وعليه مثل البيع لو مثليا. And he has to give the like of the item if fungible, وإلا فقيمته, or otherwise he has to give its قيمة, its market value. وغير العرض ملك المجيز. And if it's not a commodity, then what was received belongs to the original owner, i.e. the one who gave permission. أمانة في يد الفضولي. And it's a trust in the hands of the fuduli. But you have to be very careful in these matters, right? Be very, very careful. It's an amana, right? So if it perished without his wrongdoing, he would not owe anything. But when it comes to amanas in these kinds of things, a lot of the later scholars said, settle for half the value, right? Settle for half the value in order to avoid disputes, right? Because if an amana perishes without wrongdoing, what is owed? Nothing, right? Right. So you sold your neighbor's car, so your neighbor comes back from the hike and he doesn't have a car anymore. And you had the money and your wallet was stolen. What do you owe your neighbor now? Poor neighbor. Right? What's the mas'ala? So غير العرض, right? So if the price was not a commodity, but rather, right? Because ard is a commodity. غير العرض would be a thaman, right? They paid for it, right? Specific example, you sold your neighbor's car for $2,000. The buyer gave you $2,000. He was over the moon. He loves the VW Beetle and he wanted the 1972 model. You got the 1972 model. You put the $2,000 in your wallet. Someone came and stole your wallet. What is owed? Nothing. Right? Nothing. However, they say that because avoiding dispute is praiseworthy, in these kinds of things that relate to the rights of others, a practical way is to agree to settle for half the price. Right? Agree to settle for half the price. But that's not a fatwa, right? That would be sort of diyanatan. It's a better thing to do, right? In these kinds of situations, right? Because you acted without permission. وَلِلْفُضُولِيِّ أَنْ يَفْسَخَ قَبْلَ إِجَازَةِ الْمَالِكِ. and the one who transacted without permission can annul, right, make fasakh before the owner gives permission because he's embarrassed or whatever reason. وصح اعتاق المشتري من الغاصب إذا أجيز البيع خلافا لمحمد. So it is valid to, if one frees a bondservant, right, from one who had misappropriated it, if the sale is validated. So what's the scenario? Someone misappropriated a slave and sold it. So Mohan was a slave. Someone wrongfully captured Mohan. So he doesn't own him. Mohan has an owner. And, however, what did he do? So the ghasib sold the slave. And the buyer freed him. This freeing would be suspended, right, till that sale was approved, contrary to Muhammad. Right? وَلَا يَصِحُّ بَيْعُهُ. But then he could not be, in this case, could not be sold. وَلَوْ قُطِعَتْ يَدُهُ عِنْدَ الْمُشْتَرِي. So in this case, where the slave was sold, and this buyer from the ghasib, from the guy who'd misappropriated him, Mohan was misappropriated by Khalid, and then he sold him, and then the slave made, engaged in theft, and his hand was cut for ujiz, and then the original owner gave permission. فَأَرْشُهُ لَهُ. Then the compensation for that is his. وَيَتَصَدَّقْ بِمَا زَادَ عَلَى نِصْفِ ثَمَنِهِ. And he would give that in charity. And وَمَنِ اشْتَرَى عَبْدًا مِنْ غَيْرِ سَيِّدِهِ ثُمَّ أَقَامَ الْبَيِّنَةَ عَلَى إِقْرَارِ الْبَائِعِ أو السيد بعدم الأمر وأراد رده لا تقبل. Right? So this case, whoever buys a slave from other than its master, right? From other than the slave's master, then he regrets it, right? Because he doesn't want to get involved in all of this. So what does he do? He says, so the one who purchased, right? So Khalid purchased a slave from the slave owned by Uncle Latif, but he bought it from Bakr. Then the buyer provides proof that the seller had not authorized the sale. So what's he trying to do? He's trying to contradict his own action, right? Because if you buy, you're saying that the person had permission to sell. So now you bought it. Now you want to get out of the situation. You might realize, I spent too much on this servant. Mohan can't cook, he can't clean, he doesn't listen, he smells bad, and he's taking up too much space, and he's flirting with the other people in the house. Big problem. So he tries to prove that, he tries to establish a proof that the seller or the master had not authorized this sale. So this is a tanaqud. This is a tanaqud. Right? So it's not accepted. Right? This tanaqud, this contradiction is not accepted. Right? It's obvious what's going on. He is trying to get out of that sale. Right? لأن التناقض لا يمنع عفوا here, this is a tanaqud, he's contradicting his own action. And in this regard, there's a قاعدة فقهية that من سعى في نقض ما تم من جهته فسعيه مردود عليه. Whoever tries to take the means to negate a matter that was completed from his own side, their effort would be rejected. Okay? Because you made a sale, you made a purchase, and then you're saying there was no permission to sell it to me. So you're contradicting your own action. But if that's not quite the case, وَلَوْ أَقَرَّ الْبَائِعْ بِذَلِكَ, but if the seller admits that he did not authorize this, فَلَهُ رَدُّهُ, then, and this is in front of the judge, right? So it becomes a proof. The seller admits that, no, I had not authorized the sale. Then this, this mushtari that's mentioned here can authorize this, the person returning. And this goes back to the principle that contradiction does not prevent validity of an admission. And then some of the responsibilities relating to the bay' al-fuduli, he says that وَلَوْ اشْتَرَى دَارًا مِنْ فُضُولِيٍّ وَأَدْخَلَهَا فِي بِنَائِهِ فَلَا ضَمَانَ عَلَى الْفُضُولِ خِلَافًا لِمُحَمَّدٍ. So if someone buys a mansion, a home from a fuduli, and then and then enters it into his own building, there is no compensation due there from the fuduli. Right? So this would be if the buyer did not know that the person selling it to him is not authorized. So what's the scenario? Sidi Masir went to Damascus and he purchased this beautiful Bayt Arabi, right, this dar. But he's finding it's too small because he has 8 children and he has a few adopted children as well. He wants them all to be ulama. So he bought this dar, doesn't fit all of them. So there's a property next to it. He purchased it, right? He purchased it. وَأَدْخَلَهَا فِي بِنَائِهِ. Has Masir done anything wrong here? Say, Masir, you can speak up for yourself. Do you do anything wrong? You purchase one property, you purchase a dar, next to it is some land. So you purchase that land, unaware that the person selling it to you is a fuduli. And you expanded your dar into that land. Unaware that, right? So, but now what happens there? That's a separate story. It's coming up in the section of ghasb. The ideal case would be the original owner would realize it. Uncle Masir would take all his children, his own and adopted, in front of the owner and say, look, these are rooms for these guys, etc. The guy would be gracious and accept the market value, but he doesn't want to. He's got an offer from a wealthy Russian alim who wanted to turn that plot of land into a madrasa. So that becomes complicated. But basically in that situation, if the owner can prove that plot of land was his, whose plot of land is it? His. And Masir, poor guy, would have to remove anything he'd built there, etc. And it would have to be rectified. And details of that are coming in ghasb, in misappropriation. And then next lesson, bi'idhnillahi ta'ala, we'll look at Babu Salam. And Salam has some very interesting things. It's an exception to the impermissibility of selling something in the future. And there's also a principle, because most of what's the minimum period if anyone's prepared ahead, what's the minimum period of salam according to the matan? So he mentions conditions. And the minimum period mentioned is أقله شهر على الأصح, right? And so they say that the minimum period for the salam is 1 month. And they say على الأصح, according to the most correct opinion. Imam al-Haskafi says وعليه الفتوى, it's the fatwa position. However, as we'll see, there's more to the story, and it highlights some principles related to how our madhab works. And Sidi Abdul Latif, you can remind me of the related texts. We'll share those bi'idhnillahi ta'ala, but send me a reminder. So we'll stop there. Any questions before we close? And Sidi Abdul Latif, we'll share items of the majalla related to the tasarruf of the Fuduli from the Majalla. What are qaida fiqhiyya? Legal principle. The qaida fiqhiyya are legal principle. These are governing principles that sometimes apply in all situations. Some apply in particular scenarios. An example of a qaida fiqhiyya is that التناقض يمنع دعوى الملك, that contradiction prevents the claim of ownership. That's a qaida fiqhiyya. Or they say من سعى في نقض ما تم من جهته فسعيه مردود عليه. Whoever takes the means to cancel a transaction completed from their side, their transaction, their effort is rejected. How? Firstly, you sell something, and then you claim that, oh, I didn't own it, and they don't provide any proof that they don't own it. Do you have to return the phone because they said they didn't? The person says they didn't own it. Because if someone sells something, what is their action claiming? That they own it. Then they say they don't own it. They didn't own it. That's contradiction. So you can ignore it unless they provide proof, right? So those three governing principles, al-bayyinah hujjatun muta'addiyah. Proof, like evidence is a proof against another. But an admission counts against you, does not count against somebody else. You say, I didn't own it, is an admission. Now it could count against you. The original owner could take you to task for that, but the person you bought it from, there's a contradiction. They can assume validity, they ignore you, unless you have proof. Now caution would entail finding out, etc. But otherwise what would happen? What's the simplest way for a seller to get the thing back? Because you realize, let's say Bakr is not a God-fearing seller. So he sells an item of jewelry to Uncle Latif. Uncle Latif negotiated hard. He got it for 1,200. Then Sister Zubaydah comes by. She says, oh, I saw that item. I want it. I would pay $2,000. So just imagine the seller says, Uncle Latif, I didn't own that. Does Uncle Latif have to even give his ear to that claim? No. Right? Which is why the Prophet ﷺ said, right, and the hadith is in the 40 Nawawi, لو أعطي الناس بدعواهم, if people were given by their mere claims, لدعا يعني أناس دماء قوم وأموالهم لكن البينة على المدعي واليمين على من أنكر. The hadith is in the 40 Nawawi. أو كما قال عليه الصلاة والسلام. I said it quickly, I may have stumbled on a word or two. Right? That people were given by their claim, that people would claim the lives and property of others. But rather, the burden of proof, the burden of evidence is on the one making a claim, and the one denying must swear. And there's principles related that come later in claims, but it's meant, a few principles are mentioned here related to the rights of third parties and the tasarruf of the fuduli. Tamaman. Barakallahu ta'ala fikum. We'll stop here for today. Wassalamu alaikum wa rahmatullahi ta'ala wa barakatuh.